Hello investors, welcome back. Today we'll discuss the SEC versus W.J. Howey Company. This is the Supreme Court case that provided us with the modern definition of a security. There are many things that can trip you up in the private equity space, the definition of a security being simply one of them. This video is provided for informational purposes only to help you understand what a security is and when you may be selling one so that you can reach out appropriately to legal representation when necessary. When in doubt, reach out. Now, the great thing about reaching out to a securities attorney is they tend to be, in addition to being sharp as a tack, very friendly and forthcoming. And the reason for that is that they make a ton of money on each syndication that they put together. And so if you've got a deal and you're ready to discuss the details of how you plan to proceed, they'd be happy to take you on and to explain what's going on with securities law to make sure that you don't run afoul. Now, this video will simply cover the background and the case SEC versus W.J. Howey Company. If you're interested in the Howey Test and a more detailed approach of how courts are applying it, take a look at my other video, What is Syndication, on my YouTube channel, Horizon Multifamily. So now, SEC versus W.J. Howey. The W.J. Howey Company operated citrus groves in Lake County, Florida. Lake County, Florida is located just west and north of my key market of Orlando. Every year, they would plant new citrus groves and they would own and operate half, and the other half they would sell to limited partners or passive investors to fund future operations. Now, W.J. Howey's side of the case was that they were selling real estate. And as proof, they point out that here, we're offering a warranty deed. These people actually own the real estate that we've sold them. They also said that, hey, if you're going to own this property, obviously you're going to need an operator, somebody who is going to make sure that the citrus grove is operating effectively, harvest, collect the profits, and pass on your share to you. So they offered that you could have this related entity, Howey in the Hills, run your citrus grove. Well, over the years, 42 passive investors chose to invest with W.J. Howey, and 85% of them chose to have Howey, or Howey in the Hills, operate their citrus grove. Now, as this became a Supreme Court case, you might imagine that W.J. Howey eventually went bust. And when they did, they took these 42 investors down with them. Now, the investors didn't feel like they were sold real estate. They said that they were sold securities without a license. Now, to understand where they're coming from, we need to go back to the Securities Act of 1933 as amended 2012. In Section 2(1), defines a security as a stock, bond, note, debenture. It lists about at least a dozen synonyms. And finally, it lists an investment contract. Well, it's in Howey that we get to find out exactly what an investment contract is. Justice Frankfurter proposed a four-pronged test. First, if you're investing money in a common enterprise with the expectation of profit solely through the efforts of the promoter or some third party, then it's a security and needs to be registered. W.J. Howey Company was found to be in violation of Section 5 of the Securities Act of 1933. That is to say, it was neither registered nor did they pursue an exemption from registration. I, by the way, am not a lawyer, nor do I play one on YouTube. I'm providing this video again solely for informational purposes, again, so that you'll better understand the legal landscape and you'll be better able to protect yourself. Thank you, investors. See you in the next video.